Kinds of pleadings. Section 1 of Rule 6. Pleadings defined. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Q. Defined pleadings. Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. Under the rules, pleadings cannot be oral because they are clearly described as written statements. This is the document where a party will state his claim against the defendant, or where the defendant will state also his defense. Pleadings merely tell a story. You tell your story, the other party will tell his story. Necessity and purpose of pleadings. 1. Pleadings are necessary to invoke the jurisdiction of the court. It is necessary in order to confer jurisdiction on a court that the subject matter be presented for its consideration in a mode sanctioned by law, and this is done by the filing of the complaint or other pleadings. Unless a complaint or other pleading is filed, the judgment of a court of record is void and subject to collateral attack, even though it may be a court which has jurisdiction over the subject matter referred to in the judgment. 2. Pleadings are intended to secure a method by which the issues may be properly laid before the court. Santiago v. De Los Santos, 61 Square 146. 3. Pleadings are designed to present, define, and narrow the issues, to limit the proof to be submitted in the trial, to advise the court and the adverse party of the issues and what are relied upon as a cause of action or defense. The counterpart of pleadings in criminal procedure is information, or the criminal complaint where a prosecutor will tell what crime you are being accused, what you did, time, the victim, and so forth. Construction of pleadings. In this jurisdiction, all pleadings shall be liberally construed so as to do substantial justice. Concrete Aggregate Corporation versus CA. Pleadings should receive a fair and reasonable construction in accordance with the natural intendment of the words and language used and the subject matter involved. The intendment of the pleader is the controlling factor in construing a pleading and should be read in accordance with its substance, not its form. While it is the rule that pleadings should be liberally construed, it has also been ruled that a party is strictly bound by the allegations, statements, or admissions made in his pleading and cannot be permitted to take a contradictory position. Santiago v. De Los Santos, 61 Square 146. Construction of ambiguous allegations in pleadings. In case there are ambiguities in the pleadings, the same must be construed most strongly against the pleader, and that no presumption in his favor are to be indulged in. This rule proceeds from the theory that it is the pleader who selects the language used, and if his pleading is open to different constructions, such ambiguities must be at the pleader's peril. System of pleading in the Philippines. The system is the code pleading following the system observed in some states of the U.S. like California and New York. This system is based on codified rules or written set of procedures as distinguished from common law's procedure. Marquez and Gutierrez, Laura versus Valera, or Varela, 92 Field 373. Section 2. Pleadings allowed. The claims of a party are asserted in a complaint, counterclaim, crossclaim, third, fourth, etc., party complaint, or complaint in intervention. The defenses of a party are alleged in the answer to the pleading asserting a claim against him. An answer may be responded to by reply. Section 2 tells us what pleadings are allowed by the rules of court. In a civil case, there are actually two contending parties. 1, the person suing or filing a claim, and 2, the person being sued or defending. Q. If you are the claimant or the plaintiff, in what pleading do you assert your claim? Complaint, counterclaim, crossclaim, third-party complaint, or fourth-party complaint, etc. On the other hand, if you are the party sued, you also have to file your pleading or your defense. It is known as the answer. The defenses of a party are alleged in the answer to the pleading asserting a claim against him. If I file a complaint against you, in response, you will file an answer. In the last paragraph, an answer may be responded by reply. I file a complaint, you file an answer invoking your defenses. If I want to respond to your defenses, I will file a reply. So complaint, answer, reply. This is the pattern. Q. Summarizing all of them, what are the known pleadings recognized by the law on civil procedure? There are 7 types of pleadings: complaint, answer, counterclaim, crossclaim, reply, third, fourth, fifth, etc. party complaint, and complaint in intervention. Pleadings allowed under the rules and summary procedure. Note, however, that when a case falls under the rules and summary procedure, the only pleadings allowed to be filed are, therefore, complaint, compulsory counterclaim, cross-claim pleaded in the answer, and answers thereto. Section 3, Rules and Summary Procedure. Permissive counterclaims, third-party complaints, reply, and pleadings in intervention are prohibited. Pleading and motion. The purpose of a pleading is to submit a claim or defense for appropriate judgment, while the purpose of a motion is to apply for an order not included in the judgment. 2. A pleading may be initiatory, like a complaint, while a motion can never be such, as it is filed in a case that is already pending in court. 3. A pleading is always filed before judgment, while a motion may be filed after judgment. 4. There are only 9 kinds of pleadings, while any application for a relief other than a judgment can be made in a motion. However, there are only 3 motions which actually seek judgment, namely: A. A motion for judgment on the pleading, B. A motion for summary judgment, and C. Demurrer to evidence. 5. A pleading must be written, while a motion may be oral when made in open court, or in the course of a hearing or a trial. Complaint. Section 3. Complaint. The complaint is the pleading alleging the plaintiff's cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. Define complaint. A complaint is the pleading where the plaintiff will allege his cause or causes of action. A complaint is also called the initiatory pleading because it is actually the first pleading filed in court. It is the pleading that initiates the civil action. Rule 8 requires that it should contain a concise statement of the ultimate facts consisting the plaintiff cause of action, not evidentiary facts or legal conclusions. Ultimate facts refer to the essential facts constituting the plaintiff cause of action. The fact is essential if it cannot be stricken out without leaving the statement of the cause of action insufficient. Test of sufficiency of the facts alleged in the complaint. Determine whether upon the averment of facts, a valid judgment may be properly rendered. What are not ultimate facts? 1. Evidentiary or immaterial facts. 2. Legal conclusions, or inferences of facts from facts not stated, or incorrect inferences or conclusions from facts stated. 3. The details of probative matter or particulars of evidence, statements of law, inferences and arguments. 4. An allegation that a contract is valid or void is a mere conclusion of law. For example, Mr. P wants to sue Mr. R to collect an unpaid loan. Mr. R borrowed money from Mr. P and refused to pay. Normally, it starts with an introduction. Plaintiff, through counsel, respectfully alleges that. Then it is followed by paragraphs which are numbered. For instance, 1. Plaintiff Mr. P, of legal age, is a resident of 79 P Del Rosario, Cebu City, whereas defendant Mr. R, also of legal age, is a resident of 29 P Cebu City, where summons and other processes of this court may be served. 2. On November 7, 2018, defendant secured a loan from plaintiff in the sum of $30,000, payable within 1 year from said date with legal interest. 3. That the account is already due and despite repeated demands, defendant failed and refused to pay. Prayer. Wherefore, it is respectfully prayed that judgment be rendered against the defendant, ordering him to pay the loan of $30,000 and interest in favor of the plaintiff. Plaintiff further prays for such other reliefs as may be just and equitable under the premises. Your allegations must contain the 4 elements of a cause of action: the right, the obligation, the delicate or wrong or violation of your right, and the damage. Letter B. Answer. Section A. Answer. An answer is a pleading in which a defending party sets forth his defenses. Q. What is the pleading where you respond? It is called the answer. That is where you will state your defenses. That is why an answer is called responsive pleading. Q. Why is it called responsive pleading? Because it is the pleading which is filed in response to the complaint or a pleading containing a claim. It is where you respond to the cause of action. That is where you state your defenses. So you can file an answer to the complaint, answer to the counterclaim, answer to the crossclaim, etc. It is something which is not found in criminal procedure. If you are charged with a crime, how do you answer? By pleading, guilty or not guilty. That is the answer. When you plead guilty, the offense is not punishable by reclusion perpetua to that. It is the end. There is no writing of defenses, no written answer in criminal cases. It, pleadings, only applies to civil cases where you allege your defenses. Q. What are the defenses under the rules? That is Section 5. Section 5. Defenses. Defenses may either be negative or affirmative. A negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant, essential to his cause or causes of action. An affirmative defense is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him. Defenses may either be negative or affirmative. B. Negative defenses. Define a negative defense. It is a defense of a specific denial where you deny the statement in the complaint and you state the facts and the reasons on which your denial is based. In a negative defense, the defendant specifically denies a material fact or facts alleged in the pleading of the claimant, essential to his cause of action. Example. By the way, before I continue, please hit that subscribe button. If this audio is helping you, it is free. It makes me feel good about myself knowing that I'm helping you, and it makes me feel good about you too. Thanks. The complaint says in paragraph 2, on November 6, 2018, defendant secured a loan from plaintiff in the amount of $30,000 payable 1 year from November 6, 2018. The defendant will say in his answer, defendant specifically denies the allegation in paragraph 2 of the complaint. The truth of the matter being that he never secured any loan from plaintiff because he does not even know the plaintiff and he did not see his face before. That is a negative defense. You said I borrowed money from you. No, I don't even know you. I have not seen you before. He denies the existence of the loan. That is known as the negative defense. It is a denial of a material fact which constitutes the plaintiff's cause of action. That is why it is briefly called a defense of specific denial. Insufficient denial or denial amounting to admission. 1. General denial, and 2. Denial in the form of negative pregnant. Negative pregnant is a denial in such form as to imply or express an admission of the substantial fact which apparently is controverted. It is a form of denial which really admits the important facts contained in the allegations to which it relates. While it is a denial in form, its substance actually has the effect of an admission because of a too literal denial of the allegations sought to be denied. This arises when the pleader merely repeats the allegations in a negative form. In the example above, when the answer states, "The defendant did not secure a loan from the plaintiff on November 6, 2018 in the amount of $30,000 payable within 1 year." B. Answer affirmative defenses. Define an affirmative defense. In paragraph B, it is briefly called a defense of confession and avoidance because while the defendant may admit the material allegation in the complaint, however, he will plead a new matter which will prevent a recovery by the plaintiff. I admit what you are saying in the complaint, but still you are not. Example, defendant may say, defendant admits the allegation in paragraph 2 of the complaint, but alleges that the action has prescribed. He confesses to having borrowed money but avoids liability by asserting prescription. Examples of affirmative defenses are fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. Suppose you sue me for damages arising from breach of contract. I admit I entered into a contract, but I have no obligation to comply because the contract is null and void, or the contract is illegal, or the stipulation is contrary to public policy. Therefore, I am not bound. I admit what you say, but I am not liable because of the illegality of the subject matter of the contract. Or you sue me because, according to you, I entered into a contract and I refuse to comply. So you file a case against me for specific performance or for damages. Then I say, it is true that I entered into a contract with you. It's true I did not comply. But there is nothing you can do because the contract is oral and the contract is covered by the statute of frauds. In order to be enforceable, we should have reduced it into writing. Since we never reduce it into writing, I am not bound to comply. Counterclaims. Section 6. A counterclaim is any claim which a defending party may have against an opposing party. Example, you file a case against me for damage to your car. According to you in your complaint, while you were driving your car along the highway carefully, I came along driving recklessly and bumped your car, causing damages amounting to $50,000 for repair. Your allegation is based on negligence on my part. My answer is denial. That is not true. I deny that. I was the one driving carefully and you were driving carelessly and negligently. Therefore, if you are the proximate cause of the accident, I'm not liable for the damage of your car. That is my answer. I'm not liable because you are negligent. Because you were the one negligent, my car was also damaged. I am not liable for the damage on your car. As a matter of fact, you are the one that should be held liable to pay for the damage of my car. I am now claiming for the damage of $50,000. That is called counterclaim. Nature of a counterclaim. A counterclaim is in the nature of a cross-complaint. Although it may be alleged in the answer, it is not part of the answer. Upon its filing, the same proceedings are had as in the original complaint. For this reason, it is to be answered within 10 days from the service. Q. If your complaint against me is to recover a sum of money, should my counterclaim also involve recovery of sum of money? No. There is no such rule that these two cases should be similar in nature. De Borja versus De Borja, 101 Phil 911. It is possible for you to file a case for recovery of a piece of land, and my counterclaim is recovery of damages arising from a vehicular accident. Suppose your claim against me is 1 million. Is it possible that my counterclaim against you is 2 million? Yes. There is no rule which limits my counterclaim to the same amount you are claiming. A counterclaim need not diminish or defeat the recovery sought by the opposing party. but may claim relief exceeding in amount or different in kind from that sought by the opposing party. De Borja versus De Borja 101, Field 911. Q. You filed a case against me for recovery of unpaid loan. My counterclaim is rescission of partnership contract. Is the counterclaim proper? Yes. Although there is no connection between what you are asking and what my answer is, but what is important is that we are the same parties. If you will not allow me to file my counterclaim against you, that will be another case in the future. So to avoid multiplying suits, clogging the dockets of the court, and making the proceedings more expensive, violating the purpose of the rules, the parties are allowed to include all their claims against each other in one case. Same capacity rule. De Borja versus De Borja. Facts. A died. Of course, what survives after that is the estate. X was appointed as administrator or legal representative. W owes a sum of money to the state of A, and X filed a case against W to collect the unpaid loan. X is called the representative party under Rule 3, Section 3. W filed an answer and stated that W has a claim against X. W filed a counterclaim against X in the case. Hell, the counterclaim is improper. When X sued W, X is not suing in his own personal capacity. He is acting as administrator of the state of A. The real plaintiff is the state of A. X is just a legal representative. Therefore, you cannot file a counterclaim against X in the latter's personal capacity when X is suing W in a representative capacity. The Supreme Court said that the plaintiff should be sued in a counterclaim in the same capacity that he is suing the defendant. That is a principle to remember. Section 7. Compulsory counterclaim. A compulsory counterclaim is one which, being cognizable by the regular courts of justice, arises out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party's claim, and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Such a counterclaim must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in an original action before the original trial court, the counterclaim may be considered compulsory regardless of the amount. A compulsory counterclaim not raised in the same action is barred, unless otherwise allowed by these rules. Under the rules, there are two types of counterclaim. 1. Compulsory counterclaim and permissive counterclaim. 2. How do you distinguish one from the other? When is a counterclaim compulsory and when is it permissive? The elements of a compulsory counterclaim are found in Section 7. If we will outline Section 7, we will see that a counterclaim is compulsory if the following requisites are present. 1. It is cognizable by the regular courts of justice. 2. It arises out of or it is connected with a transaction or occurrence constituting a subject matter of the opposing party's claim. 3. It does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. 4. It must be within the jurisdiction of the court, both as to the amount and the nature thereof, except that in an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. And 5. The defending party has a counterclaim at the time he files his answer. The fifth requisite is not found in Section 7, but in Rule 11, Section 8. Rule 11, Section 8, existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he files his answer shall be contained therein. Another way of saying is that the counterclaim has already matured at the time he files his answer. That is the fifth requisite. What happens if one of these requisites is missing? If one of the 5 requisites is missing, the counterclaim is permissive in nature. Discussion of the elements. First element, a counterclaim to be compulsory must be cognizable by the regular courts. In other words, if you file a complaint against me and I have a counterclaim against you in the labor code, then it cannot be classified as a compulsory claim, because how can I invoke against you a claim which is cognizable by the NLRC before the RTC? Second element, it arises out of or it is connected with a transaction or occurrence constituting a subject matter of the opposing party's claim. The second requisite is the most important. A counterclaim to be compulsory must arise out of or connected with a transaction or occurrence constituting a subject matter of the opposing parties concerned. It must arise out of or is connected with transaction or occurrence constituting a subject matter of the opposing party's claim. It must be logically related to the subject matter of the main action. So the rule is, if the counterclaim did not arise out of or is not connected with the transaction or occurrence constituting the subject matter of the opposing party's concern, the counterclaim must be permissive in nature. Problem: Emily filed a case against Regina for damages arising from a vehicle collision. According to Emily, the case of the accident is the negligence of the defendant in driving her car. Her car bumped the car of Emily and was damaged. So Emily is holding Regina liable for the damage on her car. Regina denied that she was negligent. According to Regina, no, I am not negligent. As a matter of fact, you, Emily, were the only one negligent. And because of that negligence, my car was also damaged. So you should be the one to pay damages. Is the counterclaim of Regina arising out of or is connected with the transaction or occurrence constituting the subject matter of the opposing party? Yes, because we are talking of the same bumping. You bumped my car, you say I bumped your car. So we are talking of the same event or transaction. Problem: T files a case against me for recovery of a piece of land. According to her, she is the owner of the land which I'm occupying. Now I file my answer and then I said, T, I spent a lot of money for necessary expenses to preserve the land. You are also liable to reimburse me for their expenses for the necessary improvements I introduced on the land. Under the law on property, a defendant or possessor is entitled to reimbursement for necessary improvements and expenses. So she is trying to recover the piece of land. I am now asking her to reimburse me for all the necessary expenses that I spent on the land. Is my counterclaim arising out of or connected with the subject matter of your claim or not? Yes, we are talking of the same subject matter. Thus, the counterclaim is compulsory. Another problem: T files a case against me for recovery of a piece of land. My counterclaim against her is damages arising from a vehicular collision. Is my counterclaim arising out of the subject matter of her action? No, it is completely different. Thus, that is a permissive counterclaim. The case of Militon versus CA 216-485 held, it has been postulated that while a number of criteria have been advanced for the determination of whatever the counterclaim is compulsory or permissive, the one compelling test of compulsoriness is the logical relationship between the claim alleged in the complaint and that in the counterclaim. That is, where conducting separate trials of the respective claims of the parties would entail a substantial duplication of effort and time, as where they involve many of the same factual or legal issues. Logical relationship test. The logical relationship test between the claim and the counterclaim has been called the one compelling test for compulsoriness. Under this test, any claim a party has against an opposing party that is logically related to the claim being asserted by the opposing party, and that it is not within the exception to the rule, is a compulsory counterclaim. Its outstanding quality is flexibility. Tan versus Kagbay Finance Corporation 404 Scrap 518. What is the importance of determining whether the claim is compulsory or permissive? A compulsory counterclaim must be invoked in the same action. It cannot be the subject matter of a separate action. Unlike in permissive counterclaim, where you have the choice of invoking it in the same case or in the separate action, compulsory counterclaim must be invoked in the same action, otherwise it will be barred. This is found in Rule 9, Section 2. Section 7, as amended, includes this last phrase: a compulsory counterclaim not raised in the same action is barred, unless otherwise allowed by this rule. Rule 9, Section 2, compulsory counterclaim or cross-claim not set up barred. A compulsory counterclaim or a cross-claim not set up shall be barred. Let us try to apply that principle to the case cited. Problem: V files a case against me for damages arising from vehicular collision. Her car is damaged, my car is damaged. In my answer, I denied negligence, but I did not claim from her the damage to my vehicle. After the trial, court found the plaintiff at fault, so the complaint of V. This time, I will file a case against her to recover damages for the damage to my car, since I was able to prove that she was negligent and not me. What will happen to my case now? My case will be dismissed because I did not raise that cause of action as a counterclaim, as it is compulsory. Another problem: A files a case against me for recovery of a piece of land. After trial, the decision is against me. The court said that I should return the land to her. I will file a case against her. She moved to dismiss, barred, because I should have raised that as a counterclaim. I cannot file another case involving that cause of action. That is the effect of failure to raise the compulsory counterclaim in the case filed against you. Now, suppose the counterclaim is permissive. My cause of action against her is damages arising against a vehicular collision. Is the counterclaim allowed? Yes, allowed. My decision is not to file counterclaim, but to file another case against her. Is that allowed? Yes, that is allowed. Meaning I may or may not raise it as a counterclaim because it is permissive. I am permitted to raise it as a counterclaim, but I am not obliged. I may decide to file another action against you. That is the importance between a compulsory counterclaim and a permissive counterclaim. The third requisite: it does not require for its adjudication presence of third parties of whom the court cannot acquire jurisdiction. Meaning, if my counterclaim against you will involve the presence of an indispensable party who is, let's say, abroad, and therefore the court cannot acquire jurisdiction over him, if I don't allege it as counterclaim in my answer, I will not be barred from filing a separate action. Fourth element: that the counterclaim must be within the jurisdiction of the court, both as to the amount and nature thereof. Rules: 1. A counterclaim before the MTC must be within the jurisdiction of the said court, both as to the amount and nature thereof. 2. In an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. However, the nature of the action is always material, such that unlawful detainer cannot be set up in the RTC. That is number 3. 4. If a counterclaim is filed in the MTC in excess of its jurisdictional amount, the excess is considered waived. Augustine versus Bacalan, GR 4-6,000. In Calo versus Ajax International, GR 22-485, the remedy where a counterclaim is beyond the jurisdiction of the MTC is to set off the claims and file a separate action to collect the balance. I will file a case against you for forcible entry. I want to recover a piece of land. Where is the jurisdiction of that case? MTC. Let's review. In the law on property, even if you are a possessor in bad faith, you are entitled to reimbursement for necessary expenses. The theory there is, even if he is a possessor in bad faith, the expenses redounded to the benefit of the landowner. Anyway, you will spend them just the same as the landowner. will have to spend for them. So it will not be fair if he is not reimbursed. That is our premise. Problem. Now the defendant would like to claim for reimbursement for the necessary expenses that he spent in my lot. The case I filed against you is forcible entry in the MTC. Your necessary expenses amount to $350,000. Should you raise it as a compulsory counterclaim in the forcible entry case? No. Does it arise out of or connected with the transaction which is the subject matter of the main action? Why not compulsory? Because the MTC has no jurisdiction over the $350,000 amount for the necessary expenses. This time, that is the missing element. How will the defendant claim reimbursement? He has to file with the RTC a case for reimbursement. He cannot use that as a counterclaim for the forcible entry case because MTC has no jurisdiction on a counterclaim where the amount is over $300,000. What if the plaintiff filed against the defendant an action for action publicana, recovery for a piece of land where the value of the property is $1 million? So the case should be filed in the RTC. Now the defendant is claiming for the reimbursement of their improvements, their necessary expenses amounting to $50,000. Should the defendant raise that as a counterclaim in the action publicana case? Yes. In the first example, the counterclaim is above the jurisdiction of the MTC. This time, the amount for the counterclaim is below the jurisdiction of the RTC, so the RTC can claim jurisdiction. How can the RTC try a counterclaim when the claim is only $50,000? It is in accordance with the exception under Section 7, except that in an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. This means that the main action is action publicana, RTC. The counterclaim is reimbursement for necessary expenses, which arise out of the same land. Normally, the RTC cannot try that, but the answer to this question is yes. The RTC can award a claim for damages even though the claim is below its jurisdiction. The principle is, since the counterclaim is compulsory, jurisdiction over the main action automatically carries with it jurisdiction over the compulsory counterclaim. The compulsory counterclaim is merely incidental to the main action. Jurisdiction of the RTC over the main action necessarily carries with it jurisdiction over the compulsory counterclaim, which is merely ancillary. If the main action is with the MTC, it cannot try the counterclaim with the RTC. It is beyond its jurisdiction. It is not covered by the exception. But if it's the main action which is within the jurisdiction of the RTC, it can try a counterclaim which is below its jurisdiction, provided it arises out of or connected with the transaction. That exception is not written in prior rules, but it is recognized exception laid down by the Supreme Court, which is now written down in the law, in the case of Maceda versus CA. 176-440. Hell, the jurisdiction of the MTC in a civil action for a sum of money is limited to a demand that does not exceed $100,000, now $300,000, exclusive of interest and costs. A counterclaim beyond its jurisdiction and limit may be pleaded only by way of defense to weaken the plaintiff claim, but not to obtain affirmative relief. The fifth requisite. The defending party has a counterclaim at the time he files his answer. How can I make a claim against you which is not yet existing? Even if all the other requisites are present, the counterclaim would still not be compulsory because how can one invoke something now which he can acquire in the future? So, those are the 5 essential elements. You remove one, the counterclaim becomes permissive. Again, what is the importance of distinguishing whether the counterclaim is compulsory or permissive? If the counterclaim is compulsory, the defendant is obliged under the law to raise it as a counterclaim in the action where he is being sued. If he fails to invoke it, it is barred forever. If the counterclaim is permissive, the defendant has a choice of raising it as a counterclaim in the case filed against him, or he may decide to file another action against the plaintiff. raising it as his cause of action. It is permitted but not obliged. General rule: a compulsory counterclaim not set up in the answer is deemed barred. Exceptions: if it is a counterclaim which either matured or was acquired by a party after serving his answer, in this case it may be pleaded by filing a supplemental answer or pleading before judgment. 2. When a pleader fails to set up a counterclaim through oversight, inadvertence, excusable negligence, or when justice requires, he may, by leave of court, set up the counterclaim by amendment of the pleading before judgment. Section 10 of Rule 11. The filing of a motion to dismiss and the setting up of a compulsory counterclaim are incompatible remedies. In the event that a defending party has a ground for dismissal and a compulsory counterclaim, he must choose only one remedy. If he decides to file a motion to dismiss, he cannot set up his counterclaim. But if he opts to set up his counterclaim, he may still plead his ground for dismissal as an affirmative defense in his answer. Counterclaims in criminal cases. Javier versus IAC 171 SQA 605. Facts: the Javier spouses filed a criminal case against Leon Gutierrez Jr. under BP 22 of the bouncing check law for issuing a bad check. The criminal case was filed before the RTC of Makati. The complainants did not reserve the civil action. The implication is that the claim for civil liability is deemed instituted with the criminal case. Gutierrez in turn filed a civil action for damages against Javier's spouses in the RTC of Catamaran, Northern Samar, where he accused the spouses of having tricked him into signing the check. What happened now is that he was being criminally sued in Makati, but defending himself in Catamaran, Northern Samar. He is explaining in Samar court what he should be doing in the Makati court held. The civil case in Samar should be dismissed. It must be in the Makati court that Gutierrez, as accused in the criminal charge of violation of BP 22, should explain why he issued the bouncing check. He should explain that story in Makati and not in Samar. This should have been done in the form of a counterclaim for damages for the alleged deception by the Javier spouses. In fact, the counterclaim was compulsory and should have been filed by Gutierrez upon the implied institution of the civil action for damages in the criminal case. What the Supreme Court is saying is, since the civil action for damages is impliedly instituted in the criminal case, and he wants to hold you liable for filing this case, he should file a counterclaim against you in the criminal case. What is unique was that, for the first time in the Philippine procedural law, Supreme Court laid down the rule that there is such thing as a counterclaim in a criminal case, because normally counterclaims are only recognized in civil cases. But since the civil action is deemed instituted in the criminal case, the accused can file a counterclaim against the offended party in the criminal action. But in the case of Caballero versus Cantos 271 SQA 392, the Javier ruling was set aside. It was held that the logic and cogency of Javier notwithstanding, some reservations and concerns were voiced out by members of the court during the deliberations on the present case. These were engendered by the obvious lacuna in the rules of court, which contains no express provision for the adjudication of a counterclaim in a civil action impliedly instituted in a criminal case. By the foregoing discussion, we do not imply any fault in Javier. The real problem lies in the absence of clear-cut rules governing the prosecution of impliedly instituted civil actions, and the necessary consequences and implications thereof. For this reason, the counterclaim of the accused cannot be tried together with the criminal case because, as already discussed, it will unnecessarily complicate and confuse the criminal proceedings. Thus, the trial court should confine itself to the criminal aspect and the possible civil liability of the accused arising out of the crime. The counterclaim and the crossclaim, or third-party complaint, if any, should be set aside or refused cognizance without prejudice to their filing in separate proceedings at the proper time. At balance, until there are definite rules of procedure to govern the institution, prosecution, and resolution of the civil aspect, and the consequences and implications thereof, impliedly instituted in a criminal case, trial courts should limit their jurisdiction to the civil liability of the accused arising from the criminal case. This means that Supreme Court admitted that the Javier Doctrine put more problems and confusions in the absence of specific rules. The counterclaims should not be tried together in a criminal case. The trial court should confine itself in the criminal action, and that the counterclaim should be set aside without prejudice to its right in setting up actions in the civil action. Note, the ruling in the case of Caballero is now incorporated in the last paragraph of Section 1, Paragraph A, Rule 111 of the 2000 Revised Criminal Procedure. No counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case, but any cause of action which could have been the subject thereof may be litigated in a separate civil action. Letter D. Cross-claim. Under Section 8, a cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. Such cross-claim may cover all or part of the original claim. So a cross-claim is a claim by one party against a co-party. It may be a claim by defendant against his co-defendant arising out of the subject matter of the main action. Examples: in an action for damages against the judgment creditor and the sheriff for having sold real property of the plaintiff, the sheriff may file a cross-claim against the judgment creditor for whatever amount he may be adjudged to pay the plaintiff. In an action against a co-signer of a promissory note, one of whom is merely an accommodation party, the latter may file a cross-claim against the party accommodated for whatever amount he may be adjudged to pay the plaintiff. J and P are solidary debtors for the sum of 100,000 because they signed a promissory note in favor of D to collect the sum of 100,000 pesos. However, although J signed the promissory note, he did not get a single centavo. Everything went to P. Both of them are now sued. According to J, actually there is a possibility that I will pay the 100,000 to Dean, when actually I did not even get a single centavo out of it. Everything went to P. Therefore, J will now file a case against P, where he will allege that if J will be held liable to D, P will reimburse him. So J will also file a claim in the same action against P. Now, the claim filed by J against his co-defendant P is called a cross-claim, where J is called defendant in the case filed by D and a cross-claimant against P. P is also the defendant in the case filed by D and a cross-defendant with respect to the cross-claim filed by J. So that is another case which defendant is filing against another defendant. Limitation on cross-claim must arise out of the subject matter of the complaint or counterclaim. 2. Can be filed only against a co-party and is proper only when the cross-claimant stands to be prejudiced by the filing of the action against him. The purpose: to settle a single proceeding all the claims of the different parties in the case against each other in order to avoid multiplicity of suits. Republic v. Paredes, GR 12548. Take note, the cross-claim of J against P is merely an offshoot of the case filed by D against J and P, meaning it arises out of the same transaction or occurrence that is the subject matter of the case filed by D against them. Suppose D files a case against J and P to collect a promissory note signed by J and P, and J alleges in his cross-claim, well, since we are already here, I also have a claim against P for damages arising from a vehicular collision. Is the cross-claim allowed in the problem? No. The cross-claim is improper. It has no connection with the complaint of D against J and P. A counterclaim must always arise out of a transaction or occurrence that is the subject matter of the main action. Bar question. Distinguish a counterclaim from a cross-claim. The following are the distinctions. A counterclaim is a complaint by the defendant against the plaintiff, whereas a cross-claim is a claim by a defendant against a co-defendant. 2. The life of the cross-claim depends on the life of the main action. A cross-claim is merely a consequence of the case filed by the plaintiff against the defendants. No main action, no cross-claim. Ruiz, Jr. versus CA. In a counterclaim, you can kill the main action, still the counterclaim survives. 3. A counterclaim may be asserted whether or not it arises out of the same transaction or occurrence that is the subject matter of the action, whereas a cross-claim must always arise out of the same transaction or occurrence that is the subject matter of the action. Example, P case filed against J to collect a loan. J files a counterclaim against P to recover a piece of land. That is allowed and that is a permissive counterclaim. But suppose T files a case to collect a loan against J and P. J files a cross-claim against P to recover a piece of land. Will it be allowed? Not allowed. It has no connection with the subject matter of the main action. Take note that a cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter of the original action or of a counterclaim therein. So, a cross-claim may arise either out of the original action or counterclaim therein. Example, J and P file a case against D. D files his answer with a counterclaim against the plaintiff, J and P. So J and P will now become defendants with respect to the counterclaim filed by D. So J now can file a cross-claim against P arising out of the counterclaim. Hypothetical example. Moritz and Charles, plaintiff, filed a case against Jet and Pow, defendants. There are two plaintiffs suing two different defendants on a promissory note. Both Jet and Pow signed the promissory note in favor of Moritz and Charles. Complaint, collection case, main action. Moritz and Charles, plaintiff versus Jet and Pow, defendants. Now, according to Jet, every centavo of the loan went to Pow, so Jet files a cross-claim against Pow. Cross-claim on the main action. Defendant, Jet, now cross-claimant, versus defendant Pow, now cross-defendant. Jet also says, actually I have a case against Moritz and Charles because they entered my land and gathered some of its product. So he filed a counterclaim against both Moritz and Charles. In the counterclaim of Jet, the defendants are Moritz and Charles for the accounting of the improvements on the land. Counterclaim of Jet, defendant Jet, now plaintiff, versus plaintiff, Moritz and Charles, now co-defendant. Moritz now will answer the counterclaim of Jet. Actually, the damages on land was not caused by me but Charles. So Moritz filed a cross-claim against co-plaintiff Charles, arising out of the counterclaim of Jet. So cross-claim arising from the counterclaim of Jet. Plaintiff Moritz, now a cross-claimant, versus plaintiff Charles, now a cross-defendant. Now, according to Pow, actually last month a car owned by both of you, Moritz and Charles, bumped my car and that my car was damaged. So P filed a counterclaim against Moritz and Charles for the damage of the car. Counterclaim of Pow, defendant Pow, now plaintiff, versus plaintiff Moritz and Charles, now defendant. But Charles says, I'm not the owner of the car but Moritz. So he files a cross-claim against Moritz. Is it confusing? Cross-claim arising from the counterclaim of Pow. Plaintiff Charles, now cross-claimant, versus plaintiff Moritz, now cross-defendant. Now there are 6 cases which are to be decided in the same action. This rarely happens, but it is possible under the rules. The obvious purpose of this is to avoid multiplicity of suits, and toward these ends, according to the Supreme Court, the rules allow in a certain case and even compel a petitioner to combine in one litigation these conflicting claims, most particularly when they arise out of the same transaction. The rule does not only allow a permissive counterclaim, but the parties are even compelled to raise them in a compulsory counterclaim. In the case of Ruiz Jr. versus CA, Dean files a case against Jet and Powell. Jet files a cross-claim against Powell. After a while, the case against Jet and Powell was dismissed. What happens to the cross-claim of Jet against Powell? When the main action was dismissed, the cross-action must also be dismissed. The life of a cross-claim depends on the life of the main action. If the main action is dismissed, the cross-claim will have to be automatically dismissed. A cross-claim could not be the subject of independent adjudication once it lost the nexus upon which its life depended. The cross-claimants cannot claim more rights than the plaintiffs themselves, on whose cause of action the cross-claim depended. The dismissal of the complaint divested the cross-claimants of whatever appealable interest they might have had before and also made the cross-claim itself no longer viable, whereas the counterclaim can exist alone without the complaint. Example, Powell filed a case against Jet for the recovery of a piece of land. Jet's counterclaim is damages arising from a vehicular accident. If the complaint is dismissed, the counterclaim of Jet can still remain alive even if the main action is dead. But in a cross-claim, once the main action is dead, the cross-claim is also automatically dead too. What is there to reimburse when the complaint has been dismissed? There is an option to the effect that the dismissal of the complaint carries with it the dismissal of a cross-claim, which is purely defensive but not a cross-claim seeking an affirmative relief. If a cross-claim is not set up, it is barred, except when it is outside the jurisdiction of the court. If the court cannot acquire jurisdiction over third parties whose presence is necessary for the adjudication of said cross-claim, in which case the cross-claim is considered permissive. 3. Cross-claim that may mature or may be acquired after service of the answer. And hey, before you go to the part 2 of this audio, do me a favor please and hit that subscribe button. It makes me feel better after being seated for a long time and reading these reviewers. You know how it feels. Thank you.